You can't put your hand up and shout. If you're not speaking, can you keep yourselves on mute? It just stops interference across all screens. I think it makes the sound quality better for everyone. If you don't remember yourself to unmute yourself, someone will tell you you're on mute, because it happens all the time in these things. So don't worry about that. So welcome to this pre-examination meeting in relation to the appeal by Muirden Energy Limited against the decision by the Highland Council to refuse an application for planning permission for a wind farm comprising of 7 turbines and associated infrastructure known as Drumhalston 2 Wind Farm to be located on the Sandside Estate, approximately 2 kilometres west of Ray. Now, my name is Trudy Craggs. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by Scottish ministers to consider the appeal and determine whether or not planning permission should be granted. Now, this is a virtual meeting and is being broadcast live, and as such will be stored as part of the DPA website archives and will be capable of repeated viewing. By participating in the virtual meeting, you're consenting to being filmed. You're also consenting to the use and storage of those images and sound recordings, and to have any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. And further details of the DPA privacy policy can be found on our website. So first of all, thanks to my colleague Callum for arranging today's meeting and carrying out any testing he's done for you. He is hiding in the background and there's any technical issues, but that's his participation today, so don't worry about that. But hopefully there won't be any technical issues today. Before we go any further, I don't think anyone, from what I can see, is in the same room. If you are in the same room as someone else, can I just remind you that you should comply with government guidance on COVID-19 and any restrictions on that. We'll also ask you to ensure that phones and other devices are not audible during the session, albeit I recognise if you're not in the same room as your team, you may need to contact them by some way during the course of the meeting, which is absolutely fine, but please make sure your phones aren't audible. So I'll start by asking those who are participating today just to introduce themselves. So can I ask the lead participant for the appellant, first of all, to introduce yourself and those attending on your behalf?
Hi, good morning. My name's Robin Hutchison. I'm a partner at law firm CMS, and I'll be representing the appellant. And I'm joined by Angus Elder, who is head of planning with the appellant.
Thank you. Now, I understand that the Council and Nature Scott have got joint representation. So can I ask lead participant for both to introduce yourself and those who are appearing today on behalf of both parties?
Yes, good morning, ma'am. My name's James Finley, Queen's Counsel. You're correct, I'm jointly representing Nature Scott and Highland Council. From Nature Scott, we have Debbie Skinner and Catherine Harry, and from Highland Council, we have Karen Lyons, Simon Heinson, and Claire Farmer.
Thank you, Mr. Finley. And finally, for Caithness West Community Council, could you introduce yourself, please?
Yes, I'm Gillian Bundy and I'm the chair of Caithness West Community Council.
Okay, thank you very much. Now, Mr. Kelly, who represents Rawog, if I pronounced that correctly, was due to participate in the meeting today, but he has advised my office this morning that his Wi-Fi issues have not yet been resolved, so he's not going to join, but he is content obviously to go ahead and he'll provide any feedback when he gets them into the meeting in due course. So this is all I'm expecting to participate today. So we can move on to item 2 on the agenda. This is really just to reiterate what the purpose of the meeting is today, and it's to discuss the procedural arrangements as I've set out the agenda, which was circulated last Thursday, and hopefully you've all had a chance to look at that. There will be no discussion on the merits or an impact of the case, and will not hear any evidence today. I will be keeping a note of our discussions this morning, and after the meeting, the case officer will circulate to all parties who have attended the note of the meeting with the key decisions and the procedural meeting arrangements, and that will be in the form of procedure notes, which is quite important for going forward. The proceedings today are progressed in accordance with the Town and Country Planning Appeals Scotland Regulations 2013, and these can be accessed through our website if you're not familiar with them. I will also put a hyperlink in the note of the meeting, so they're easily for those who haven't seen them to to find them on the website. The purpose of the regulations is to ensure that the issues identified for consideration by a reporter are dealt with in the most appropriate mode, such as by way of an inquiry, a hearing session, or by further representations. All of the written material already submitted, including all of the representations, will be taken into account in the consideration of the appeal, regardless of what procedure I use going forward. However, having looked at the documentation I've got so far, I do consider that I need additional evidence on some issues, which is the point of the meeting today. So just move on to item 4. To get the additional information, I consider that the most efficient way to do so would be by oral process, either by a hearing or an inquiry session. And I did flag in the agenda that I was minded to hold hearing sessions, but I will allow all parties to comment on that and have their views on that shortly. In line with our current guidance, no in-person oral procedures can take place at this time. So today I'm working on the assumption that the oral sessions will be held virtually, and we'll come on to that in a wee minute. The intention would be that we'd broadcast those oral sessions live so that anyone interested can also watch the proceedings either as they're happening or later, which again makes it accessible to anyone who has an interest or is in the process or just wants to see what's going on. For an oral virtual session, I will programme with the detailed arrangements, which will set out timings for the sessions because they're slightly more regulated than we do for in person. And I'll also set out guidance and protocols, and that will be 2 weeks before the start of the oral sessions. And again, if anyone needed any further IT testing for additional witnesses you might want to bring into the process, that will be carried out in the 2-week period before the oral process starts. Having said all that though, I accept that the guidance may change, given we are in the lockdown restrictions easing, and that may happen before we have a planned virtual session. So I thought that it would be worth convening a second pre-examination meeting virtually with the parties who are participating week commencing 20th of June, which is round about the time when the Scottish Government is likely to announce any move to level 0, if that's where we're going to get to by the end of June. And hopefully at that point we'll have updated guidance for moving, if we've moved into level 1 by that point anyway, which we should know then if we can do in-person inquiries or not. So I thought it was worth doing that at that point. We can discuss at that session any changes required to the arrangements for the oral sessions, and we can discuss at that point whether we think we can move into in-person sessions, which should give us sufficient time to put the arrangements in place to have it in person if we think that's the right thing to do at that point in time. If we have face-to-face procedure, it is still likely we'll require a venue that can address and accommodate some public health protection measures. And I just wondered if the parties were aware of any suitable venues that they could tell us of now, so at least we can make some investigations at the appropriate point if we think it's appropriate to move to an in-person inquiry or oral sessions. So I don't know if that's something for the council or the community council to comment on.
Ma'am, there is a venue called the Way In, which has a very large room, and the first Lime Kilns inquiry was held in. Whether that's still available or not, I don't know.
I might be able to assist there. We had a look at the same venue actually, thought it might be suitable, and also we thought it might be sufficient size to ensure that we could adhere to COVID protocols. I think it's available for the proposed dates in September. We haven't looked, I hadn't had a chance to look at any later dates, but it certainly seems to have good availability at the minute, so we can certainly pass those details to the DPA.
Okay, thank you for that. I'll pass those on to the case officer. And clearly, if we've used it before, we'll have a contact there anyway, and we can check availability when we get on to looking at dates. But that's really helpful to know that there is an option if we think it's appropriate to move into in-person procedure. Okay, so if we move on to item 5, and this was the provisional assessment of the issues that I think require further evidence and the procedure that should be followed. So you've got the agenda. Before we discuss the procedure, can I just go around and get parties' views on the issues and the matters that I've listed there, and whether there's any other matters you think should be listed? So if I can start with the appellant, please. Ms. Hutchison?
We're content. We're happy with the list of issues.
Mr. Finlay?
Likewise.
And Ms. Bundy?
Yes, happy with the list of issues, thank you.
Okay, great. That was relatively straightforward. Thank you for that. So as I said earlier, I'm minded to hold hearing sessions rather than an inquiry session. Now, before I move on, I just want to make sure everyone understands the difference between a hearing session and an inquiry session. Ms. Bundy, I'm not sure if you've been involved in hearing sessions before, so I just want to make sure you were quite clear as to what the difference was.
Yes, I'm clear of the difference, thank you.
Okay. So on that basis that everyone understands the difference between the two processes, I'll go around the parties asking for their views on procedure. I think if it'd be helpful from my perspective, if you bear in mind that the purpose of the oral sessions is to enable me to obtain the evidence I need to determine the appeal. So that's really the core purpose of the oral sessions. It's not to kind of have a go at other people's witnesses or other people's evidence. It's really to get the evidence I need to allow me to determine the appeal. So on that basis, Ms. Hutchins, do you have a view from the appellant's perspective? And I would say, before we go into this, that you can have different processes for different issues that I flagged. So keep that in mind as you're going through it. So if for example, an inquiry session for the first bullet point, but you thought the last one could be done by hearing, that's absolutely fine to mix and match, so to speak. So Ms. Hutchison, can I start with you?
Yeah, no, thank you. I mean, generally, we were, very happy to go along with whatever you consider to be the best process to get the information that you need. We're pretty happy to go with the flow. We did have 2 or 3 observations, which I would just make now. Firstly, in relation to wildland and the proposed hearing, the appellant did consider that perhaps written submissions might be sufficient, particularly given that there is quite a body of consideration given to this by the previous reporters for the previous scheme. So it's been quite well examined already, which may be of assistance. But I think we do appreciate that others may have a different view on that. So that's our view on wildland. Secondly, just a general observation, and it maybe relates to the previous point on the scope of issues, and that is that we hope that there's quite significant scope to reduce the issues, at least as they, in terms of areas of disagreement between the parties. So I think it's 6.3 of the agenda, statements of common ground, but we certainly would propose to try and progress those and hopefully narrow and focus the discussions that we do have. And then the third and final comment just on process is conditions and the conditions hearing. And obviously we've got the benefit of a second PEM in late June, early July, and we'll have the draft conditions and comments on them by then. So maybe we just revisit the extent to which that's necessary to have a hearing session on those, depending on the levels of disagreement or anything that you consider you need further on those conditions.
Okay, thank you. I agree. I think I flagged in the agenda that it might not be necessary to have a hearing session on the conditions if actually through the written submission process we get to a point there's a high level of agreement on that. But that's really helpful, particularly about the wild land and the agreed statement. I always think it is good if we agree the matters as far as we can and narrow the issues in dispute. It just means the oral sessions, particularly if they're virtual, could be a lot more focused. And I found doing ones previously that's been really helpful and easier, more efficient for the virtual sessions. Mr. Finlay, do you have any comments in response to that from the council's perspective and Nature Scott?
Well, yes. Can I start off by saying that in our view, we support the suggestion of hearing sessions for both landscape and visual and wildland. As to wildland, agree with what Mr. Hutchison says, but first of all, it is an important matter, and secondly, the background assessment. If you've read the John Holliston decision, you'll note there was a dispute as to which guidance should be used, and the reporters understandably chose the older guidance, but I think now both parties have agreed the newer guidance should be used, and that's exactly the sort of matter you may wish to ask questions on. So in our submission, it would be sensible to have a hearing session for both. We don't press for an inquiry session. I echo Mr. Hutchinson's points about statement of agreed matters, and Highland Council are regularly involved in producing them, and particularly with policy, that hopefully is capable of being significantly reduced as an issue. And indeed, we canvass a point whether, as with conditions, that may be possible to dispense with a hearing session for that. And we are obviously, there's some time away from agreeing conditions, but we're reasonably hopeful, I think, as Mr. Hutchinson was, that conditions will be substantially, if not wholly, agreed or capable of agreement. Again, Mr. Heinsohn in particular will be dealing with that, has considerable experience of that over a number of inquiries this year already.
Okay, thanks, Mr. Finn. That's really helpful. So it might be worth, when I think about this after the meeting, having further submissions on the policy aspects to again try and narrow that down, to focus it at the point we come to the next pre-examination meeting as to whether we have an oral session or not, which is possibly worth doing again if we can cut down the oral process time that we need. So that's helpful.
Could I perhaps suggest that almost the easiest way to do that may be to try and have a very early statement of agreed matters on policy, and then have written submissions on the matters that are in dispute. That may be the far more effective way of dealing with it, because certainly our experience to date has been, and I don't know who Malone Friend is using in terms of policy, is that there is quite often substantial areas of agreement on policy and quite limited areas of disagreement, and that quite often comes down to issues of judgment and weight, which can be expressed quite shortly in submissions.
If I may just agree with that, actually, we were going to make a similar suggestion in relation to statements of agreed matters, that if we were able to try and agree an early statement of agreed matters on policy, perhaps in time for the next PEM, so that the reporter will be able to take a view on what the best procedure is at that point, having had the benefit of narrowing as far as we can. I would say perhaps just that the appellant's provisional view, though, is still that our preference would be a hearing session if the reporter considers that is helpful still.
Okay. Okay, that's really helpful. Ms. Bundy, can I come to you and ask for your views on the procedure?
Yes, thank you. From Caithness West Community Council's perspective, we did want to retain an involvement in the inquiry process to see how things developed. We clearly have no funds to lead expert witnesses in any of the sessions, so it may well be that we're relying on Highland Council and Nature Scot now that they are involved, and we clearly don't want to add anything in terms of time or input to sessions that are already being adequately covered. So I think from at this stage, if it's acceptable for us to retain some limited involvement, but probably we won't lead any particular sessions, and perhaps make a request to submit some a written statement on behalf of local residents.
Okay, that is appreciated, that approach, and I'll think about how best to add that in, so that you can have some involvement and provide a written statement. I think there's quite a lot of broad agreement there on how the process should be going forward, which is helpful. I'll have you think about how best we should do that. But I do like the idea of having an early statement of agreed matters to on the policy aspect to try and narrow that down, followed by potentially further written submissions, and as a last resort, perhaps a hearing session. So based on that, I'll go away and think about that and confirm in the procedure notice. Moving on to the prior disclosure of cases, as you'll all be aware, there's a number of written exchanges which require to take place before oral sessions, to ensure that all parties are fully aware of the case made by others on the opposing side. Now, the first point to make here, this is for all parties, and it's just a requirement under the regulations. You all have 14 days from the date on which the note of the pre-examination is issued to confirm that you wish to take part in all or any of the oral sessions. Now, I will highlight that in the note of the meeting in bold so you don't miss it, but it's just a requirement of the regulations. Now, I'm assuming the appellant and the council and Nature Scot will take part in all the oral sessions, and the Community Council, you could indicate that you wish to take part, as in participate and be there to hear what's going on. You can sit as a member of the audience or in person, or you can log on and join virtually, which would allow you to participate to a limited extent. So you can have a think about that, but just remember to come back to the case officer in 14 days. And I will find out from Mr. Kelly what Rabble want to do, which sessions they want to participate in too.
Sorry for interrupting. Technically, Nature Scot won't be involved in the landscape and visual session, and technically Highland Council won't be involved in their wildland session. But that may be just a pedantic point, but I thought I should make that clear. That there's going to be no duplication of evidence. It'll be just one witness in each of those sessions from only one of the parties.
Okay, I had probably assumed that Nature Scot would not participate in the landscape and visual, but the council might participate in wildland. But that's fine. Just Nature Scot, they're relying on Nature Scot's case for that.
Yes.
That's absolutely fine. Thanks for clarifying. Okay, so on the agenda, I put in an Annex A, a provisional timeline for the submissions, and this was based on oral session starting on the 6th of September. So if we think about when we might start the inquiry session, the hearing sessions, and a likely duration of those sessions, we can maybe do that first. Now, from the response I've got so far, Mr. Hutchison, your client can do any time in September, but not week commencing the 4th of October.
That's right, yeah.
From the Council on Nature perspective, you can do the week commencing 4th October and the week commencing 25th October. And I've just had an email through saying that you may be available on the Thursday, Friday of week commencing 27th September, but that's to be confirmed.
Yes, ma'am, perhaps I can explain that. I'm due to be I have a 4-week hearing in the Lands Tribunal, which is due to finish on the Wednesday of that week. So I would be available on the Thursday and Friday in an attempt to try and find a date that's suitable to all parties. And if there was to be as to timing, you'll obviously know what information you need, and on the basis there are going to be hearing sessions, it seemed to us, at least provisionally, it may be possible to deal with hearing sessions for wildland and landscape and visual within 2 days, in which case that's why we were 2 days. That was the basis on that assessment. It may be the Lands Tribunal will go short, but I obviously can't rely on that at this stage.
Mm-hmm. Ms. Hudson, do you have a on duration of the sessions?
I mean, I think our view was similar to Mr. Finlay's, that a day for each of landscape and visual and wildland would be sufficient, and perhaps half a day on policy. I mean, I think our view would be still that we could cover, in fact, all 3 in the 2 days if we were to truncate wildland a little and perhaps share the day wildland and policy and on landscape and visual. Those were the 2 most student days for everybody.
Okay, I want to avoid a situation where we don't have enough time, and then we're trying to find a day later on to kind of wrap things up. I agree. There's no reason why we couldn't do it in 2 days.
Now, can I make a suggestion that in terms of potential policy and conditions, instead of their customary position being tail end Charlie, you take them potentially first on the Wednesday, as there's no absolute necessity for me to be there for them. Mr. Heinsohn can deal with those. He's an experienced witness, particularly if there's going to be a limited ambit of dispute, which will have been significantly focused by that stage. And that would allow the, if it is going to be 2 days, the both days to focus on just the two issues of wildland and landscape and visual impact.
That's really helpful. I did actually wonder if you would be acceptable to you, because I did wonder if the conditions and the policy could come first on the basis that by that point either there's nothing in dispute, therefore we don't need a hearing session, or it's very limited at that point as to what needs to be covered in a hearing session. So that would make me feel more comfortable that we would have enough time to get everything done between the Wednesday for conditions and policy, and then the Thursday and Friday on landscape, visual and wild land. So is everyone content that we set down then for week commencing 27th of September, we do the Wednesday, Thursday, Friday?
Yeah, we're
setting down
happy
the
with
3
that.
days. Okay, that is really helpful. We'll also look at later on how we fit site actions round about those dates, but we'll come on to that. So just looking at Appendix A, that's out of a provisional timeline. Obviously, we're moving the oral sessions towards the end of September. I propose keeping the same general timeline. I'll just move the dates out a little bit, given that the oral sessions are later. I can take out any reference to inquiry statements, precognitions, things like that, since we're not having any inquiry sessions. And I would like to factor in the early submission of the statement of agreed matters. And probably from looking at that Annex A, would it be possible for parties to do that by the 10th of June? So at the same time as the draft conditions and any heads of terms are being submitted, the statement of agreed matters could also be submitted at that point.
Unless Mr. Elder tells me otherwise, I think that will be fine for the appellant.
Mr. Finlay?
Nothing. Good.
Ma'am, I was going to suggest that if we're starting at the end of September, you might want to push the date for the second pre-examination meeting back, just to give us as much possibility of having some certainty as to what's taking place. So that date.
I could push that back by a couple of weeks, and then we should hopefully definitely know as to where we are, and then push the other dates before that back by a couple of weeks as well. That helps. I'm not wedded to that week commencing 20th June. It just fitted in with that timeline. But I agree, if we have certainty slightly later on in July, I'm happy to do that.
I've just had a message from Mr. Heinsohn. He'd appreciate if that was to be moved back a further couple of weeks if possible, because he's got quite a busy timetable between now and June. But in principle, we should have a statement of agreed matters, including matters not agreed, by a week before, whenever you fit the second pre-examination meeting.
So a week before that meeting, you'd have the statement of agreed matters.
Yeah.
Ma'am, if you're happy with that, the appellant's happy with that, that seems reasonable.
I will look at the timeline, but in principle, I am happy with that. I would recommend that you also engage with both the Community Council and RAWOG on this. Part of the process of reaching agreement on the agreed matters, as opposed to coming in at the end and having to comment on it. I think that'd be more helpful. But I'm, in principle, if that was a week before we had the next pre-examination meeting, I think that would work absolutely fine. So that would take us into July. I will ask Case Officer Samira just to look for people's availability, because the school holidays and things like that during that period. So I'll make sure we get a day that suits people. The pre-examination meeting would probably take an hour at that point, because it'd be very limited as to what we're actually discussing at that point. But that all sounds fine from my perspective. So I will amend that line. What I've done for previous hearing sessions, and I'll do it regardless whether it's virtual or in person, is that I have issued very detailed agendas in the form of specific questions, which should give parties sufficient time to prepare when they come to the hearing. And I tend to issue those a couple of weeks in advance, giving parties a week to come back with any comments or additional questions or areas they want to explore, to give parties, again, sufficient time to prepare for the actual hearing sessions, to make it easier if it's virtual, and just allow people more time to prepare if it's in person. So I do the same for this oral sessions in this case too. Even though we're not having an inquiry session, I would probably ask parties if they want to submit a closing submission at the end of the process. I always find it's quite helpful to wrap up their case at that point based on the evidence that I've heard. That would be done in writing. I would give parties time at the end of the process to lodge closing submissions. Obviously the council, RAWOG and the Community Council going first, with the appellant following a few days later. But we can agree dates for that at the end of the oral sessions at that point, which is to flag up that I would probably appreciate written closing submissions. There are no legal submissions. I dread to kind of mention the word legal submissions, but if any party is considering making any legal submission, please do that as soon as possible, so we're not affecting the timeline and the timetable as we go through the process. But hopefully there aren't any, but I'm just flagging that up.
Not at this time, certainly from us.
Good. Moving on to item 7. For all parties, to remind you that any documents, including written submissions, inquiry statements, hearing statements, precognitions, everything like that, should be shared electronically with all parties involved in oral sessions and copied to the case officer. Now, it is assumed if you're participating and want the exchange of information, or you're going to lodge something, that you have no objection to the DPA circulating your email address to the other parties participating to ensure the efficient circulation of submissions. So, Ms. Bundy, you're probably one that's got a personal email address. Are you happy that that is shared with the other parties?
Yes, I don't have any issue with that.
Okay, thank you. I just wanted to check from privacy perspective. It wouldn't go any further. It wouldn't be out with the group that are participating in the oral sessions. One thing that we have found works well for virtual sessions is having a single document list. So as well as having core document list, which I'd quite like the appellant and the council to pull together a core document list, having kind of below that as appellant documents, council documents, but on one list, all the documents that parties may rely on. It just avoids trying to jump from one document list to another when you're in a virtual session, and you may have various windows open with different documents. A single document list could be provided. That would be very helpful. I don't know if the appellant could take the lead on that and liaise with the other parties. It's not that many more documents to be submitted on the back of what I've got already. And please don't feel the need to create documents if what I've got is sufficient, or the evidence is there. You just want to pull it in a different way for the hearing sessions. But if the appellant could lead on that, that would be helpful.
We would be happy with that.
And also on the back of that is memory sticks. And again, this is also helpful if we have a virtual session. We find that if you're relying on pulling documents off online as you're going through a hearing session, there's a lag, or there is, depending on your Wi-Fi connection. So a memory stick is very useful to ensure that all documents are there and you can just get them up fairly quickly. So again, we usually ask the appellant to provide document sticks, memory sticks to all parties with the documents, all the documents on them. I'll put a date in that in the agenda if that's acceptable to the appellant, and if the parties can confirm where they'd like the memory stick sent to, we can let the appellant know that. So is the appellant okay with that?
Again, unless Mr. Elder's nodding, yes, we're happy with that. Great.
Okay, that's fine. What I tend to do when it's been a virtual session is at the start of the hearing session, or even an agenda, what I've done is I've listed the documents that I think I would want to refer to. When we come to the virtual session, you can have all the documents ready in tabs, which makes it slightly more efficient. That doesn't include other documents being referred to, but it just allows the session to be slightly more efficient at the start without people scrabbling around and trying to find documents. But the memory sticks do help, we found. And from my perspective, even if it's in person, a memory stick will be helpful for me for coming to the oral sessions. Currently, during the period of restrictions, there's no need for the council to place any of the material for the case on deposit. It is all on our website, so it's published there, so there's no need at this point. Again, I don't know if that'll change or not, but if it does, we will flag that up going forward. So moving on to item 8, the site inspection. Now, I intend to carry out an unaccompanied site inspection before the oral sessions take place. We are now authorised to do site inspections unaccompanied in terms of the current guidance, where it involves an overnight stay, which was the one we couldn't do before, so we can do that. So I anticipate doing that. I will maybe probably go up possibly June to do an unaccompanied site inspection. In line with our current guidance, in exceptional circumstances, a reporter can undertake an accompanied site inspection where the circumstances of the case require it and where I'm satisfied it can be undertaken safely. But parties attending must be kept to a minimum. We've got to ensure social distancing at all times, have to wear masks, things like that. Now, I think in this case, it is essential I do an accompanied site inspection to make sure I'm at the right places, looking at the right things. So I think it would be beneficial from my perspective to do that. And given the type of case it is, I think it would be beneficial, I'm happy to take parties using this, to do one before we have the hearing sessions and then one after we have the hearing sessions. The first one, so we're all familiar and can make me familiar with what we're looking at. And the second one, to mop up anything that comes out of the oral sessions that may need a second look at something. Now, I know it means people going up potentially twice to do site inspections, but I just wondered what parties' views were on that. So I'll start with Mr. Hutchinson.
We're very happy to facilitate whatever you consider to be most helpful. I did have a comment or suggestion just on how we arrange the site visits and preparations for the day, which I can raise later once everyone else has had a comment on.
You can raise it now, that's fine.
Well, great. I was just going to suggest that perhaps in line with the timetable for preparing statement of agreed matters, the appellant canvasses views or opinions on what a sensible itinerary might be, just so that each party's had a chance to put forward where they think the key stops should be, just for your consideration. Obviously, we'll adjust the itinerary to whatever you want to see, but that might be helpful.
I was going to come on to itinerary. That would be, I was asking the parties to pull one together because I think it is helpful to get parties' views on that, on a shared itinerary, and then it gives focus to the company site inspection. Mr. Filling, do you have views on the timing of the site inspections?
No, in principle, none, but can I respectfully ask, there are two types of site inspections. The wild land, I think last time, as appears from the reporters, and perhaps it was lucky there were two of them, spent quite a lot of time walking themselves through the wild land area. And it's a question of whether you wish to be accompanied on the wild land aspect as well as the other aspects, and which is fine, but it would, I imagine the wild land aspects will take a day probably by themselves. I don't have at the forefront of my mind the detail of the evidence. There may be certain viewpoints within the wild land that you need to get to, and actually may be quite difficult to identify, so that an accompanied, at least part of that accompanied may be of assistance to you. But I just note that there may be need for two separate types of site inspection, one dealing with wild land and one dealing with the viewpoints, which, if I recollect correctly, are mostly fairly either accessible or easily ascertainable.
Okay, that's helpful. I will bear that in mind. Based on having hearing sessions at the end of September, I wondered about the end of August for the first site inspection, as they were probably looking at end of early October, end of September for the next one. Finally, given that we're constrained, it's your availability that's constraining us, we could even do the first one just before the oral sessions. That week commencing 27th September. I'm open to parties' views on that. I'm trying to avoid people going up and down on numerous occasions. So if it was on the Tuesday before we start on the Wednesday, we could see what we could do in that day, and then we could have one later on in October for if we thought we needed one after the oral sessions, or it may be after the oral sessions I feel I can go out by myself and do an unaccompanied one based on what I've done already. So that kind of be the options, I guess.
I mean, the September suggestion has a very practical benefit in that I know the appellant's landscape and visual witness is available that week. I don't have her availability to hand for the rest of the summer.
Okay.
Perhaps if I make just one other observation, actually, on the timing and itinerary for the day. Mr. Finlay makes a very good point about the accessibility of the wild land, and perhaps the parties could discuss the extent to which we think practically it's possible to view the wild land and the various viewpoints in one day. Mr. Elders advised me that the appellant's got access to a couple of Argo cats, which might assist for at least one wildland visit, make things a bit quicker.
Yeah, that would be helpful. I suppose a slight caveat to that is whether we can share cars at that point in time. I don't know what the process would be. Maybe it would be wearing masks. I'm not sure. I think it'd be helpful when at this point, and I'll clarify this in the notice meeting, to focus on the landscape and visual viewpoints, because I think the wildland I possibly could explore the wildland on foot by myself, and I could come up a few days earlier before the oral sessions to do that. But if we can focus then on doing that first accompanied site inspection on the Tuesday, the 28th would be, when you know your witnesses are around, that would probably be quite useful, and we could focus on landscape visual at that point. I will have a look at the wild land as well, and I'll give you a view in the note as to whether I think we need to focus on that for the accompanied or more the landscape and visual aspects, and how much I think I could cover of the wild land by myself. Maybe if there was some pointers as to the best access points, things like that might help me to be able to do it by myself. But I'll have a think about that and confirm that in the note. And then we may want to do one afterwards, but again, we can discuss that at the end of the oral processes as to what we think I would still benefit from going back to see again, whether that needs accompanied or whether I could do that by myself, having gone out already with everyone being accompanied. So we'll use that as a starting point. Again, we can revisit that at the next pre-examination meeting, because the guidance might have been updated and we get more clarification as to whether we can all go in a vehicle and be driven around, or whether we can't at that point. So if that itinerary could be produced at the same point of the statement of green matters, that would be helpful, and then it could both be discussed at the next pre-examination meeting. Okay, so we're moving on to the last couple of items on the agenda. So the DPA contact, inquiries should be directed to Samira Akbar, but I'm assuming we've all had correspondence with her so far. She is case officer just currently dealing with the case. It was Colin Bell, but he's not in the office at the moment. I'll put her contact details in the notice of meeting so you have that to hand. And finally, is there any other issues any party wants to raise, either that I haven't covered or anything that has come out of the meeting today that you want to raise at this point? Mr. Hutchison?
No, not on behalf of the appellant.
Ma'am, there is just one point, and it's just, given we're more or less fixed on the end of September, it would be, and given my involvement in other things before that, it would be helpful if you could, when you're arranging the timetable, perhaps add an additional week towards the end of the session, so that, particularly after your agenda's been issued, so that I have more opportunity to liaise with the witnesses than might otherwise be the case. I'm not suggesting anything in particular, but if you could just, I could ask you perhaps to bear that in mind when fixing the timetable, that would certainly be of assistance to us in preparing.
I think given the fact we've got a reasonable amount of time between now and then, I think that's totally doable. So I'll see what I can do for you.
I'm much obliged. Thank you very much.
That would actually be.
So I was going to say it's beneficial to all parties to ensure everyone comes prepared. So I've got no issue in trying to factor that in and give them maybe 3 weeks from the point I put the agendas out to the actual hearing sessions, if that facilitates coming and having a more productive hearing session. There's no point in people coming feeling unprepared. Doesn't benefit anyone. I'm sure, as Mr. Hutchin's going to say, he's got no issue with that either, if it gives him and his team more time to prepare too. So I can't see any party having a problem with that.
Absolutely.
So that was very short and sweet. We're kind of at the end of the process. Normally this pays people to drive carefully home or to their offices. Nowadays, you just say thank you for participating and you can now leave the meeting. But thank you very much. We will be in touch next week with the note of the meeting. That'll come out before or on the 20th as per the timetable, setting out what we've agreed and the timeline there. But thank you all for your cooperation. I think I've got everything out of that I need. And I'm glad we've got a date in the end of September rather than kind of drifting into October, November time for the oral sessions. And hopefully by having the statement of agreed matters, we can condense that as much as we can and focus on just the key issues. So thank you all. I'll let you all leave the meeting.
Thank you very much.
Great. Thank you very much.
Thank you.
Cheerio.
Okay.